咁我哋
Members, I call to order the meeting of the Subcommittee on Consular Relations, Additional Privileges and Immunities, Cambodia Order and Consular Relations, Additional Privileges and Immunities, Philippines Order. We have formed a quorum, so let's elect a chairman. Are you nominating me? So Mr. Sin Chung Kai seconds. I'm happy to accept the nomination. There won't be another candidate because there are just 3 of us. So let's invite the administration to join us.
Hello. 好。
I would like to introduce the public officers to you. We have Mrs. Du Peng Wei Yi, Deputy Director of Administration from the Administration Wing, Ms. Melody Hui, Senior Government Counsel from DFJ, Mrs. Judy Lee, Director of Protocol from the Administration Wing, and Ms. Lonnie Ng, Senior Government Counsel from DFJ. Let's get on with it quickly. Mrs. Du, please tell us why there is a need for the privileges and immunities. On the 23rd of September 2015, the electoral brief was sent by the government to the Legislative Council, and this is in relation to the privileges and immunities for the consular posts set up in Hong Kong in relation to Cambodia and the Philippines. If I may briefly talk about the 2 consular conventions, and I would like to brief you on the major points. For the bilateral consular convention between PRC and the Kingdom of Cambodia, and that between the PRC and the Republic of the Philippines, on the 12th of January 2011 and the 13th of July 2013, they applied to Hong Kong. 50 articles for the convention in relation to Cambodia, and then 51 for the convention with the Philippines. Most of them can be implemented by way of administrative arrangements or covered by the Vienna Convention on Consular Relations. We have the VCCR standing for the 1963 Vienna Convention on Consular Relations. According to the usual practice under common law, we have to introduce domestic legislation so as to provide for the additional privileges and immunities. Well, we are talking about the inviolability of the residences for consular officers, personal inviolability for consular officers and their family members, immunity from the judicial administrative jurisdiction except in certain civil proceedings for consular officers and their family members. We need to protect and preserve the estates left in the SAR by deceased nationals of these estates, safeguard the interests of the nationals who have a right to property left in the Hong Kong SAR by a deceased person, and receive for transmission to the nationals money or property in the SAR to which they are entitled as a consequence of the death of another person. For the P's and I's I referred to, they have already appeared in 2 other orders. are mainly concerned about the first 3 items. But of course, there are also other provisions involved. If the chair and members are interested, you are welcome to ask questions. For the bilateral consular conventions, they have been promulgated under Article 18 of the Basic Law. And in fact, they apply to Hong Kong. And according to the usual practice of common law, bilateral agreements applicable to Hong Kong which affect private rights and obligations or require exceptions to be made to the existing laws of the Hong Kong SAR should be underpinned by way of domestic legislation. What we need to do is to set out the provisions expressly and specifically. On the 28th of May 2015, we have already submitted a paper to the LegCo panel on administration of justice and legal services. Then, in relation to the administration of estates by consular officers ordinance, as well as the Consular Convention's application of Section 3, or the Consular Convention's ordinance, we've also prepared some other orders. The relevant orders have already been introduced into LegCo for the purpose of negative vetting. They will come into effect on the 11th of December 2015. After going through the process, we are happy to take questions from members. Yes, we do understand the case concerning the Vienna Convention on Consular Relations. For the additional privileges, please tell us why we need them and what are they. Well, let me talk about the major additions. For the Cambodian order and the Filipino order, they are very similar.
So I will not separate the two, if you don't mind. When it comes to the definitions, an addition is, say, for example, when it comes to archives, well, apart from just general documents and instruments, there is an addition to keep ahead with the times. When it comes to archives, it is to protect means of archiving, say for example USB. So you're saying, well, if you refer to 30, that is inviolability of archives and documents, and that includes memory device. Yes, I understand that. So it's not within the consular premises. Well, in any way, it is consular archives. Say, for example, there is police and some things are found, and the Cambodia consulate said that this is used to store consular archives, so it cannot be taken away. Is that right? Because my previous understanding is that consular archives will situate within consular premises. Perhaps I will defer to the DOJ. May I add that when it comes to the Article 30 of the two orders, that is inviolability of the consular archives and documents, is the same as the VCCR, which says that these items shall be inviolable at all times and whenever they may be. And you may ask, if it's the same as the VCCR, how come we have to copy it? It's included. because the scope of archives and documents has been expanded. So, well, in the past, consular archives and documents are protected no matter where they are. It's just that the definition has been expanded by including digital or electronic devices. So all the other orders will have to be revised. Well, this hasn't happened before. The one that is added is the Russian one because the definition of archives and documents has been expanded. Well, we have signed this with a lot of countries. So if it's because of this technical point, we have to update all the orders. So you have to come back to us. Well, for existing orders, unless there are new orders, new agreements or additions, you may recall for existing orders, we decided whether certain things were included in the order given the then situation. Well, you know that nowadays no consular will use paper only. That means you will have to come to the LegCo for updates very often. Is that right? Well, these agreements are signed between two countries. So if there is any change, it will be an agreement between two countries. So if they don't discuss it with the CPG, we will not just make changes for them. I understand what you're saying. You are only looking at it from the procedure perspective. But what about the content? We can't do it by way of subsidiary legislation or local legislation. Because we're talking about bilateral agreements. There won't be a way to just introduce a change once and for all to include all electronic devices. Is that right? As far as I know, no. So if a country wants it updated, then it will be done on a case-by-case basis, right? If a country thinks that it is necessary to introduce additions, then there will be changes. We'll say, for example, there are agreements entered into maybe dozens of years ago. So will there be a way that it can be dealt with that will include, say, electronic devices? Well, in the past, say, for example, documents, and does it include documents stored in computers? If there are disputes, it will be for the two countries to discuss it, or maybe it will have to be decided by the court as to whether the existing definition can be read wider. But in the case of the order, it's because of the expanded scope in the agreement. That's why we have to add that. But as to whether there will be disputes in the operation and how it's to be dealt with because time has changed, well, it will have to be decided later. The agreement is entered into by both sides, and in the past, let's say for argument's sake, the term used is document. Thus, the Hong Kong SARG has the power to interpret the law to say that it can include storage, modern storage devices. You just think about it first. If you're not clear about it, maybe you go back to do some research before you explain to us, because the government will have to have a stance. Say, for example, for the older orders, there is a case, the police found something. The police find something, and the consulate claims that it is consular archive, and it is not physically present in consular premises. Then how do you direct the police to interpret the agreement under the law to whether protect the device or not? You can't wait till it happens. I'd like to get an answer from you. So tell us whether the DOJ thinks that the word document can be read in a wider way, or is it the case that it is limited only to documents? And it's a very important stance, and also a legal interpretation of the Hong Kong SARG. What you say may not affect the two orders under scrutiny, but I'd like to hear from you what you think. But we may not wait for your answer before we decide whether to endorse the two orders. Do you understand? The second thing, well, what are the additions? Well, they've all appeared in the order, but I'm just going through the salient points to draw your attention to them. Tell me what you've added. Well, the things that have been added are in the order. Don't tell me. Tell me what has been added. So with your agreement, I'll only go through the salient points. But if you want me to do it article by article, then I'll do that. Just first go through the salient points. Another one is the inviolability of consular premises and the residences of consular officers. Currently, it only refers to consular premises, but for the two orders, we have added residences of consular officers. Please wait there. You said that originally it's just the consular premises. You now say that you've added residences of consular officers. Well, for the residence, it's not written in this way in the VCCR. So how many countries have had this updated? Please give me a minute. Just give me a ballpark figure. A few, a dozen? Just give me a minute. We have given you a table. 8. 8, including what we are dealing with now. And I find it quite strange. It doesn't appear in the VCCR. There is another more important one. Is personal inviolability of consular officers, because under the VCCR is about consular officers and officers working at the consular. And for Section 34, Article 34, it's a wider scope of protection. And apart from these two orders, there are other countries that are afforded this protection, namely UK, US, Vietnam, and a number of other countries that have previously entered into similar agreements. There are altogether 7. So Article 34 is in general terms, or what? In the past, it's only the Consulate General. Now it includes consular officers. No, previously it's the Consulate General and consular officers, and now we've added family members. No, sorry. No, I wasn't talking about Article 34. I beg your pardon. I wasn't talking about Article 34. I was actually talking about 28. Sorry. I wasn't talking about Article 28. I was talking about family members. It should be 41. Privileges and immunities of family members. So I want to ask about this P&I, this privilege and immunities. I understanding is that you have added that for family members. And in 28, it's very clear that if it's just simple criminal cases, say for example damage of properties and getting drunk, they cannot be arrested. 28 is about premises. You cannot enter the consular premises and residences of consular officers. And 34, it says a person of consular officers. Yes, 34 is about personal inviolability. So it means that wherever they are, there will be personal inviolability, right? 34 means that if consular officers, say for example, have committed traffic offense, you cannot detain them, you cannot arrest them, you will have to respect their freedom of person and dignity. Say for example, someone's damaged something in Lan Kwai Fong, police can't arrest them. No, they can't. So as long as they show the proof of identity, that you cannot arrest them, right? I'll defer to the DOJ. According to what you said, they are not liable to detention or arrest. That means you cannot arrest them or detain them. But when it comes to serious incidents, I think it depends on the actual situation. But just now you talk about 41. I think it's related in some way to 34. But the wordings are not entirely the same. I fully understand 34, but when it comes to 41, whether it is exactly the same as those related to consular officers, do you think it's the same? Well, for 41, there are different levels. We're talking about family members of consular officers and those of administrative and technical staff. They shall respectively enjoy the privileges and immunities to which the consular officer and the member of administrative and technical staff are entitled. That means if a consular officer enjoys a certain privileges and immunities, then his or her family members will enjoy the same. And if it is a technical staff, then the family members will enjoy the same level of privileges and immunities applied to that technical and administrative officer or staff. So is it a matter of fact, or you will have to go through certain procedures to confirm that they are family members of consular officers?
I'll defer to my colleagues. Currently, for the definition of family members for the Cambodian order, we have already got an explanation. There is a definition for family members. So under Article 1H, family members means the spouse of a member of the consular post and their minor children who live with them in the same household. In the case of Philippines, they haven't got a definition. Under international law for family members, the general concept is that we refer to the spouse and their minor children. When there is a wider definition, it all depends on the specific provision in the relevant convention. Maybe Mrs. Du can also tell us the following. That is, without a specific definition, what do we mean by family members? Maybe Mrs. Lee can supplement. I think Ms. Hui is right. For us in the Office of the Director of Protocol, it depends on whether the convention has been signed. Say in the case of Cambodia, it is clear. Otherwise, we just take into account the international convention. Some of them have their parents with them in Hong Kong as well, but they don't enjoy the privileges and immunities. Do you keep a register of the names of their family members? Or would it suffice as long as it is a fact that a member is the spouse of a member or they are the minor children? Well, for every officer, when they come to Hong Kong to report duty, the passport as well as the relationship has to be stated to us. What about family members? So as long as the police consult the office of the Director of Protocol, then it can be confirmed whether somebody is defined as a family member, and that would suffice, correct? Mr. Chairman, if I may ask a general question in the first place. Mr. Chairman, I understand that you are familiar with the case of the VCCR, but I am not quite familiar, so can I ask some general questions? Yes, please go ahead. Now we are talking about bilateral conventions, a convention between the PRC and Cambodia, and also another convention between the PRC and the Philippines. I better stay put and give the floor back to you, Chair. Please continue with the additions. For the additional privileges and immunities, for the orders pertaining to Cambodia and the Philippines, they have immunity from jurisdiction, except in civil proceedings. And then for a member of the service staff, and also for a member of the administrative and technical staff of the consular post, there are also certain immunities. And then that's in relation to liability to give evidence. And then they are also exempted from certain services. The receiving state is such that for the sending state, there is exemption from the customs duties and taxation of the receiving state. That's in relation to the property, the consular posts, as well as the members. So we're talking about an expansion of the privileges. I don't quite understand your view. Say, for example, for Article 35, except in civil proceedings arising out of a contract, arising out of any professional or commercial activities. Understand that in many countries, the consular staff will not take part in any business activities. But my understanding is that in some cases, individual consular staff members may be engaged in business activities both in their own country of origin or in the receiving state. So what do you mean by official functions? So are we talking about SOEs or sovereign funds? Say, for example, if somebody is also responsible for promoting investment, will that be counted towards his official functions? Because somebody may be responsible for promoting investment, and then he may be asked to sign certain documents as well. So what will be included and what not? Well, it depends on the facts of individual cases. When it comes to official functions, then it must be that this person is working for his state. It is clear from the VCCR for the establishment of a consular post, I think is for exchanges in the cultural as well as the business sectors. But then that's for exchange. I think it's up to individual states to decide what is official function. So I want to know what's meant by official function, defined by the laws in Hong Kong or what? Now we're talking about immunities. Is it up to the sending state to say that that consular officer may sign a contract on behalf of the sending state? So that in this case, nothing can be taken to the court because he is protected. Well, for the bilateral convention, say in the case of Cambodia, please go to Article 5.4. It says that other than carrying out functions, a consular officer cannot take up any jobs. Which one? Chapter 5, Section 46. I'm referring to the bilateral convention. You mean the convention between PRC and Cambodia? Which one? 46, paragraph 4. Well, in fact, they have to discharge functions, and for functions, official functions, you'll find it in Article 4. Just a moment, I think it will be useful. They have already set out the scope of the functions. So they cannot have, they are not supposed to engage in any professional commercial activities other than their official functions. So they are not supposed to engage in any commercial activities. Yes, it is already set out in the convention. So they can't say that somebody asks a consular staff or a consular officer to say that he should also sign a contract. He cannot do so. I assume that it is commercial activity. It appears that he is not supposed to do that. Mrs. Du. For the additional privileges and immunities, I think I've covered all of them briefly. Um, 18 out of the 50 articles are the additional ones. So I have just covered the so-called additional privileges and immunities. If I may share with you my observation. I think you also talk about protecting the estates of a deceased national. But then we may have the scenario in which people are fighting for the estate. Maybe a child involved in the fight for the estate is also a permanent resident of Hong Kong. When you talk about protecting the estate, in what circumstances can our court deal with it? Or would it be up to the consular staff say that it is under protection, it is exempted, and so the property will go back to the sending state? Well, let's take a look of the convention with Cambodia. If we try to look at Article 46 under Chapter 5, General Provisions. Just a moment, please. Yes. It says that without prejudice to the privileges and immunities, it is the duty of all persons enjoying such P's and I's to respect the laws and regulations of the receiving state, including those governing traffic control. They also have the duty not to interfere with the internal affairs, and they are not supposed to engage in any professional commercial activities. And then it says that with the prejudice to the P&Is, they have the duty to respect the laws and regulations. So when they are in the receiving state, they have to respect the laws or regulations of the receiving state. For the electrical brief, in paragraph 7D, it talks about protect and preserve the estates left in the SAR by deceased nationals of these states. If somebody passes away in Hong Kong and there is the estate left in Hong Kong, then it should be subject to the laws of Hong Kong. You have quoted Article 46. I want to know about the relationship or whether there is any contradiction. For paragraph 7D, can you tell us, well, how it has been reflected in the order? We have got two other orders for Cambodia. And there is the Administration of Estates by Consular Officers Ordinance. No, you are talking about the additional privileges and immunities. Well, for our electrical brief, it covers the 6 orders and not just 2 orders.
It doesn't matter. So for the administration estates, and also if a national has estate in Hong Kong for the nationals back in the sending state, then they will be covered by those 2 orders.
Now, how are the other 2 orders implemented? As I said, there are 2 other orders. One is Administration of Estates by Consular Officers Ordinance, Cap 191, and then there is the other one, that is the Consular Conventions Ordinance, Cap 267. It covers administration of estates by consular officers. That is, the Consulate General can, on behalf of its national, receive estates left by the deceased nationals and pass it on to their own nationals. And these orders will be enacted so that these provisions will apply to these 2 countries. What if it's a Hong Kong permanent resident that is also a national of their country? Say, for example, there are some savings with the HSBC Bank. So it's for the court to deal with the case, or the consular can, or is it the case that the consular can write a letter to the HSBC and take away the savings? Under Cap 191 and also Cap 267, the amendments target cases, say for example, when a national of the respective countries pass away in Hong Kong and there is no administrators or administratrix in Hong Kong. So that person, the deceased person, is all alone in Hong Kong. With the amendments, the consular can deal with the estates. But sometimes that time is of essence, but it will take time for applications to be made. So does it mean that the consular will deal with the estates through Hong Kong court? Yes. It's just to give them the capacity to make an application to the court to deal with the estates. So it's someone who owns a piece of antique in his home. Then procedures will have to be complied with before that piece of antique can be taken away. Yes. And it's in the case that where there are no other people making applications, because if there is, say, a family member making the application, then there is no need for the consular to do it. So if there is a fight over the estate, it would be dealt with by Hong Kong court, right? Well, then, under the basic law, when it comes to foreign affairs, it's for the two countries to enter into agreements. But the practice is that after they've sign an agreement, then the whole document will be passed on to us to ratify it, and there is no place for us to ask questions or to not adopt it. Yes, we can rescind it. Let me explain that where we don't participate or we did not participate during the negotiation, normally after agreements have been entered into, the CPG will inform us. And for the negative vetting exercise this time, let me explain that the two agreements apply to our national laws. That means it actually is effective in Hong Kong. This domestic legislation is only to underpin the agreements. Perhaps I will hear from the legal advisor if it is vetoed. Does it mean this still is in effect? I think the officials have explained as to whether we can change it or do anything to it. Under the general clauses and interpretation ordinance, the piece of legislation can be changed, but we will have to comply with our powers when it comes to subleg. So under the Consular Relations Ordinance, the CE is empowered to, based on the international agreement signed, set out the power of additions so that the agreement can be implemented in Hong Kong. So if there are amendments, it will still have to make sure that the agreements can be effective in Hong Kong, or enforced in Hong Kong. So as to whether we can veto it, say for example, Sin Chung Kai moves a motion. Of course, I won't do that. I don't have the reasons to do that. But just in the case of vetoing, because in theory we can veto it because it's negative vetting. What will be the implications? No, let's leave that aside. First, whether we can veto it, whether the president will allow you to move that motion to veto it. Shall we hear from the legal advisor? Well, there are two separate things, whether the agreement is enforced or whether the subleg is enforced. Perhaps the legal advisor can look into it before coming back to us. Maybe we will hear from the DOJ? Yes. Let me add that it seems that the legal advisor has explained it before, because similar questions have been asked in the subcommittee, and it has been answered. Mrs. Du? Well, at that time, the legal advisor told us that, yes, that the legal can, under Section 34 of Cap 1, to deal with it by way of negative vetting, but it is the foreign affairs related to the Hong Kong SARG, so there can be limited amendment to the wording. The substantial content of the subleg cannot be changed. So in theory, yes, it can be vetoed. But I'd like to explain clearly that since it is national law, then it applies to Hong Kong. Even without domestic legislation, the provisions are enforced in Hong Kong. I'll say, for example, family members of consular officers and the officers themselves. It means that Hong Kong police cannot search them. May I? We do it under Article 18, the basic law. That is in relation to the regulations of the People's Republic of China concerning consular privileges and immunities. They are already in force. So it's already part of the laws of Hong Kong under Annex 3. And they are already part of the laws of Hong Kong. And we have to come back here because we have a tradition of common law. And there may be conflicts or inconsistencies with existing domestic legislation. Or there may be extra powers. So, well, if it's vetoed by the LegCo, but since it's already part of the laws of Hong Kong and there are inconsistencies, what will happen? Do you mean that there is an international agreement that is not consistent with domestic legislation, or whether there are any conflicts? From the perspective of international agreement, we will have to interpret our domestic legislation so that it will be consistent with international agreement. So we will follow the international agreement. This is a bilateral agreement that is already in force. But still, we have to go through domestic legislation so that these privileges and immunities can be clearer to the general public. But there is also a word. Yes. I noticed that in the Cambodia order, Article 30, in the English version, it used the word document, but in the Chinese version, there is only one term, consular archives in English, so the word document is missing. And in Article 35 under Part 5, the Chinese version refers to arising out of any professional or commercial activities in the receiving state by a consular officer outside of his official functions. The Chinese rendition is slightly different from a similar provision in other order, because the Chinese rendition is different, because one is related to professional, the other one is more to occupational. We base that on the Chinese agreement between the two countries, so where we don't have the freedom to change the wording. So you're referring to the actual agreement entered into, and this order is to implement the agreement, yes, or the convention. Yes, but we have to copy and paste the terms. Well, we have to do it by way of we have to introduce a domestic legislation so that usual or common terms used in Hong Kong can apply. No, in our what is already stated, let's refer to the Cambodia order, or the Cambodian order. Article 3. Article 3, it says it is declared that what? Article 3? No. Consular relations, additional privileges and immunities, Cambodia order. First is commencement, 2 is interpretation, and 3 is additional privileges and immunities. No. We have Article 1 definitions. 1 is commencement. And the interpretation is in relation to convention and relevant provisions of the convention. Oh, I see, section 3. It is declared, it says, that the additional privileges and immunities accorded to a consular post of Kingdom of Cambodia under the relevant provisions of the convention, and they have been cited on the right-hand side under the articles, and it says that they have to be read together with relevant provisions or articles to have the force of law in Hong Kong. So the articles in this schedule actually are copy and pasted from the words in the International Convention. I want to ask the legal advisor, you are talking about now I understand. Perhaps maybe some countries won't sign the don't have a Chinese version of the convention. Perhaps the Chinese version followed some of the Chinese versions of convention signed before, and this time the different word is used. Legal advisor. So, for example, for it's changed from 職務 to 公務, which is one is the former is professional, and the second one is official. And there is now a different rendition. But if we refer to subsidiary legislation that are already in force, that is the Consular Relations, Additional Privileges and Immunities, Russia order. For the Chinese version, the term 公務 is used, and in other places the word 專業 professional is used instead of 職務. For the Russian convention, is there an official Chinese version? If there is it the case that a different term has been selected, and this time with the Cambodian convention a different Chinese word is used, and perhaps for the Russian convention is only a translation, then it's nothing to do with us.
Mr. Chairman, I just want to explain. If there is an official Chinese version, then we have to follow. In the case of Russia, if there is a footnote to say that this is merely a translation, then it is not an official version. For those which have already got the editions, do they have official versions? Official. So we don't know why the Minister of Foreign Affairs have chosen a different Chinese rendition, and we have to follow suit. Correct. all we can do is to reflect this observation. That is, they have used a different Chinese rendition for the official versions. For Article 50 of the Cambodian order, I think towards the end of it, it has said that it has been signed in duplicate in 3 languages, all 3 texts being equally authentic. So we have to adhere to the original version. Mr. Singh, any questions? No? Then we have completed the work. What else we have to do? What about reports and all those things? We need to give time to the Secretariat to write up the report. So it's better if we sort of extend the scrutiny period so that we can read the report as well. So what are the days involved? So we are going to seek an extension on the 4th of November to have it extended until the 2nd of December so that we can have time to write the report. All right, thank you. Task completed. Thank you.